use of these, it's akin to a mugshot. He's in some kind of prison garb or cell block garb. And for that reason, we are objecting to the use of those three photographs as they are prejudicial in the sense that they look like a mugshot. So then there's a whole nother issue, but I don't know if you want to deal with that first.
Yeah, let's deal with the photographs first. So let me pull 238, 239, and 129?
129.
Hang on. Well, they're all part of the same sequence.
Yes.
I believe so.
The photos were taken by evidence specialist Mohammed Salameh on March 25th, 2025 at around 5:40 p.m.
Okay, Mr. Garner, the state's position on the defendant's motion to preclude.
Yes, Your Honor. First of all, State's Exhibit 129 was the head-on direct photograph of the defendant. The original intention for this photo was just as a documentation of who Mr. Salameh recovered the buccal swab from. That being said, so State's Exhibit 238 and 239 show the defendant's side profile from right and left views. As the trial and the evidence has developed, it has become clear that defense intends and is claiming self-defense in this case. These photos show the extent or the severity of the defendant's injuries on the date after the incident. And essentially show very, very minimal, if any, injuries to the defendant. So they're highly relevant to rebut the claim of self-defense. The level of potential prejudice is not high as, well, it's been clear to the jury after the testimony of yesterday that the defendant was in custody. The risk of unfair prejudice does not substantially outweigh the high probative value. So these photos should be admitted.
That's what I'm taking as well, Mr. Otake. I mean, the prejudice of the mugshot is to not indicate to the jury that the defendant is in custody, but that is not a danger at this point in time. Anything else you want to add, Mr. Otake?
On that issue, I mean,
Over defendant's objection, subject to the laying of proper foundation, was marked for identification of states exhibits 129, 238, and 239 can be proffered against if they're admitted into evidence. Mr. Otake, you had another issue.
yes, the other thing that was included on the state's new exhibit list is they have now have S2, State 242, State 243, and State 244. And this is what I was talking about the other day, which clearly now they're doing, right? So I was trying to address this thing without now them strategically using things and making like they're the ones giving it to the jury instead of us. But, you know, whatever, you want to play those games, that's fine. But to take our exhibits, the clips that we made, and now relabel them as state's exhibits, I mean, that's ridiculous. So if they want to use it, it remains as defense exhibit 179, 180, and 182. If they want to use it, they can use it. But that's not how we do it. In the middle of a trial, you take the defense exhibits that we made and gave, and now try to make like it's your exhibits. And there's no need to do that except trying to mislead the jury. Never seen it before. So they should remain as defense exhibit 179, 180, and 182, and they're free to use it. Just like we've used state's exhibits. I mean, this is, and not to mention, like, if that's the case, then they've never produced those things to us. So, and there was deadlines for discovery, there's deadlines for exhibits. So you don't just take our exhibits that we made and relabel it to make it like you're not trying to hide something from the jury. Go ahead and use it, but leave it marked as the way it was.
These are clips of how long? Of what length?
Short clips.
And the original body cam video for Officer Chun was how long?
Very long. I don't know, 20 minutes. 20 minutes-ish.
I'm sorry, 20 minutes?
Yeah, I don't know.
I think it's around 27,
Yeah,
but it's fairly long.
20 to 30 minutes. So we took the time to make these clips, produce it, label it as defense exhibits for parts that we believe, were relevant. And, I'm not saying he can't use them, but let's not do this shibai thing where we're labeling it as a state's exhibit and making it like they're the ones who wanted to give this clip to the jury and turn it over and label it as a state's exhibit. I mean, that's just ridiculous. And it shouldn't be allowed for all, because the time for marking state's exhibits and turning it over to us has long passed. So they can use it, just leave it marked as a defense exhibit.
Mr. Garner.
Well, I strongly object to the characterizations Mr. Otake is making about this. The reason the state added these exhibits to our exhibit list is we believe the defense's intention is to enter only a short clip of Officer Chun's body cam. And I want to note that by previous ruling of the court, the entire body cam of Officer Chun, which the state does intend to introduce, has been redacted entirely of audio. So what the jury gets from the state, the entire body cam, no audio at all. So we believe the defense intends to introduce some statements that were made for the purpose of trying to make it look like, or to try and minimize Arielle Konig's injuries by essentially saying she can talk okay. By essentially saying, oh, her voice is fine. These additional clips are a completeness issue. They show some of the difficulties that Arielle was having speaking that day. There's a non-hearsay purpose.
I'm sorry, let me catch up with you, Mr. Garner. Back up about 10 seconds.
Sure.
These clips show what?
They show Arielle Konig speaking to Officer Chun at the Poly Lookout. So she is relating things related to the events. Just a moment, I'll get my sheet with my write-up.
And while you're looking, I'm sorry, Mr. Dirks, I have a question for you. Court asked defense to provide a clip that defendant wanted to introduce via cross-examination of Officer Chun. I did have a chance to review it. Was that just one exhibit, or is that the entirety of the 3 clips that defendant had marked?
That's exhibit 182, and that's just one exhibit.
Understood, okay,
Yeah.
thank you.
And if I can just quickly clarify, just so we don't waste more time. So 179, 180, and 182, we did produce, okay? Now, what I'm saying is, anything that is admissible, and these may or may not be, he can try to admit them if they're admissible. We can talk about that, but they don't need to relabel them, is my point. Number one. Number two, 182, these other 179, 180, they may go beyond the non-hearsay purpose that we're planning to use, and it may be a problem for other reasons. Because if she's describing the incident and what happened, that's hearsay, right? So my first issue is I have no idea why we need to relabel anything to make it look like it's their clips. Number two, some of these clips may or may not go beyond what the court may allow as it relates to body cam because of hearsay issues.
179 and 181 is what you're talking about.
179 and 180.
So I don't see the state having relabeled 180.
We did not.
Yeah, they only have 179 and 181.
I don't know. What I'm looking at here, what was handed to me, S243 says Defense Exhibit 180.
Oh, I apologize.
So I don't know.
I might have mislabeled that on the.
I think it's 181.
Well, I don't know. I mean, what makes you think that? Because it says 180 on the thing they gave us.
The exhibit by electronic
Oh, okay.
copy that I have says 181.
I'll double check it myself as well.
But is there a 180? There must be a
No.
one. There's no 180?
So what I have in the exhibit folder is State's Exhibit 242, which purports to be defendant's 179.
Oh, I see. In terms of what they gave you this morning.
Correct.
Got it.
Right, and then 243, State's 243 is what purports to be defendant's 181.
Okay, so this is a typo, so it's really Defense Exhibit 181.
Correct.
Okay.
And then State Exhibit 244 purports to be what has been marked as defendant's 182, which the court did have opportunity to review.
Correct.
Okay.
And, off the top of my head, I haven't, it's been a while, I haven't memorized what's on 179, defense 179 or defense 181, but I'm just saying there may be other problems with that we need to address. But at the very, like, my point is none of these needs to be relabeled, especially 182. But I would need a minute to go back and watch 179 and 181 to make other objections as far as, hearsay, talking about the incident and things like that.
Okay, you want to do that now? Because it's going to come up with Officer Chun, right, or Corporal Chun?
Yes, I think if we have a second to look at it now, that would be helpful.
It'd be helpful for the court too, because
Okay.
I did view 182 defendants. It's probably best for me to review 179, 181.
Sure. Do you need me to speak about the relabeling thing that's been brought up?
I'm sorry?
Do I need to speak about the relabeling issue that's been brought up? Because, look, if I want to enter the exhibit, I need to be ready to enter the exhibit. I don't need to go ask defense counsel for their exhibit. That's just normal. So I don't see any problem with relabeling it, just to make sure that the exhibits I want to introduce, I have available to me. I know what the officer has reviewed, what he signed David on the disc. So that's the purpose in relabeling. It's not to hide anything. But I do want to add that, it also avoids that risk of, by defense's motion, or by defense's request of the court, the entire clip has been audio redacted, right? And then suddenly defense is now introducing audio, and that makes the state look like we're hiding things, which is not the purpose. We're just trying to follow the court's order with the audio. So it cuts both ways here. There's nothing wrong with labeling these exhibits as mistakes if we want to introduce them.
Just a couple comments on that. I don't know what he's talking about. The court ordered us to turn over electronic copies of our exhibits to each other, which we did. So this idea that he can't get the defense exhibits, he wants to make sure he has access to them, I have no idea what he's talking about. The way it works is we turn over our exhibits, we mark them, we make exhibit lists with the court's deadlines, within the court's deadlines that are set. And that's what we did here. You don't, in the middle of the trial, take our exhibits that you can just use and use them as defense exhibits and relabel them and make like they're your exhibits. I've never seen that in 20 years of doing this. I mean, and he can say what he wants, but I mean, it's very clear why he's doing this. We're not dumb, we're not stupid. So he can say what he wants, like just use it as defense exhibits, which is what happens in every trial. Like we've used some state exhibits throughout this trial.
Anything else with respect to these video exhibits? And I have one more thing before we go off record to review the clips.
I have nothing productive to add.
Then with respect to my last thing on my checklist before we recess, the live coverage, which you're welcome to have, and student members of the media, you're welcome to continue to live stream the proceedings. I would ask though that when we are not on record, that both audio and visual not be broadcasted. And the reason is this. During our recesses when we're not off record, the attorneys need to confer, they need to confer with court, defense needs to confer with Dr. Konig, and that should not be part of the broadcast made available to the public. So I would ask if the media could comply with that. Any problems with that?
Copy that.
Okay, thank you very much.
One other comment, Your Honor, and again, I'm not saying it's this is the intent, but I've been told by people watching that at certain times there's been zooming in on what's on our table and on our computer, and I'm not saying that that's the intention to try and do that, but people have said it appears that way, and they've told us be careful, don't leave things on your desk because they're zooming in on it. So I just ask that stop as well. You can whatever, zoom in on whatever you want, but just just be cautious about trying to zoom in on our work product on our table.
Agreed.
Thank you.
Anything else before we take a recess?
No.
Nothing to see.
All right. Recess.
Can we go watch it in the? Go ahead. In the back there.
Or witness room, whatever you want.
Thank you.
This cop is in the witness room.
We're offering it not for the truth of the matter asserted. In other words, we're not offering it to show what she's saying is true. We're offering it for a non-hearsay purpose of demonstrating what her cognitive ability and situation was, what her physical consciousness was following the incident. And obviously, that is incredibly important in this case. Self-defense, defense. You know, her injuries, the amount of force used, her condition immediately following the incident, you know, all goes to the reasonableness of the force that was used. So it's incredibly, incredibly important, and that's, you know, frankly, the best evidence of her condition right after the fact. We purposefully chose 182 because the questions she's answering during that clip is non-substantive as to what happened up on the mountain, okay? She's in 182, defense 182, he's asking her about what kind of clothing Gerhardt was wearing, his height, his weight, I think where he works is asked, his hair color, and the type of, potentially the type of car that's, I think, I can't remember, the car that they drove to there. So, nothing to do with the incident up on the mountain, all about just non-substantive things that demonstrate how she was cognitively, how she was physically, how she was in terms of her level of consciousness. All proper non-hearsay reasons. And we were going to suggest that the court give a limiting instruction that it's only being offered not for the truth of the matter asserted if the state wants a limiting instruction on that. It's not being offered for the truth of the matter asserted. There's very little danger of the jury using that in improper ways because, again, it has nothing to do with anything she's already said or anything about what happened in the mountain. It is incredibly, incredibly important exhibit to our defense because it is the best evidence right down there, right after, of her consciousness, of her condition. Now, if the state now wants to use defense 179 and defense 181, the difference is 179 and 181, and just so the court is aware, we made those exhibits in case we needed to impeach her with it, in case she said something different. We weren't using those exhibits to show this issue of consciousness and physical whatever, because it's very, very substantive what she's saying in 179 and 181. So we made those exhibits for the purpose of if she said something different, we could impeach her with those exhibits, right? So it was not going to be admitted unless it became impeachment. 179, she's, you know, you can hear her saying, you know, he said, you know, you lying bitch, you know, you whore, I can't do this anymore. Things that she frankly didn't even say on the stand, number one. 181, even more so. She's saying, I told him don't leave our kids without parents. He was, you know, bashing my head with a rock, you know, 10 times. So she's getting into the substance of what happened. And now we're getting into, you know, if you know, rules related to prior inconsistent statement and the foundation for that, or prior consistent statement and the foundation for that, which has not been laid. And there's a much greater risk that the jury is going to hear these things and not be able to consider it, you know, for anything other than not factor it into their their decision about what happened up on the mountain in terms of, you know, what is substantively being reported about it. So those are very, very different in that regard. So we are objecting to 179 and 181 coming in. And frankly, you know, if you compare 179, 181 to our 182, she's got essentially the same demeanor. She doesn't seem any better or worse on those than she does in 182. And so this idea that we're going to put that in to show that she was worse or whatever, again, I think that's a farce. I think they want to get in these substantive statements, and there's rules related to that. You know, they could have tried to do it with her if they wanted to, you know, lay the foundation for prior consistent or prior inconsistent statement. They could have tried to do that. They didn't. So now they want to backdoor it in, saying it's non-hearsay when it is the substance of it is goes to the heart of what this whole case is about, the substance of it. You know, it's not, oh, why did she do what she did next, or typical non-hearsay things, right? So we deliberately took 182, and these are all, you know, it's all in the same conversation. It's not like, oh, one is from here and then another's 30 minutes later, right? This is all in the same conversation. But we made one to show her condition at the time that had no substance in terms of what she's saying happened on the mountain. So you take away that risk of, you know, allowing in these substantive statements about what happened. So for those reasons, 179 and 181 should be excluded for that reason as well.
Thank you. Mr. Barney?
First off, Your Honor, when you introduce a statement of a person for a non-hearsay purpose, the content of that statement does not matter. When it's not for a hearsay purpose, whatever the person is saying, the jury is instructed on a limited purpose that they're allowed to consider it for. These two exhibits, states 242 in defense 179 and states 243 in defense 181, show a difference in condition. They show a difference in condition to what defense is putting in defense 182. They show Ms. Konig panting more, having more difficulty speaking. They give a clearer picture of what she was like closer to when she came down the hill. So when she came down that trail. When she got down the trail, she started receiving medical treatment from a bystander. Then states 242 and 243 came about. And then afterwards, defense 182. So this is a completeness issue in the fact that I understand the non-hearsay purpose defense is saying, but once you say it's for a non-hearsay purpose, and once we all agree to that, the content doesn't matter. So the same non-hearsay purpose for introducing the defense exhibit applies to the state's exhibit. It's just to show her condition, to give a clearer picture of the jury of Ms. Konig's condition, so that the jury doesn't get this tiny edited picture when in reality she was having a whole lot more struggles than the defense exhibit 182 shows. And a large portion of this trial has included defense's attempts to minimize Ms. Konig's injury. This is just another way they're doing it, and this is just a response to that attempt to minimize the injury. The same instruction should be given for each of them, if the court allows them, of the purpose that they are able to consider the exhibit for. The juror is going to be presumed to follow that instruction, and it should be gone that way. Lastly, prior consistent statement. The defense did impeach Ms. Konig with a motive that defense alleged occurred after Ms. Konig made this consistent statement. So as long as the officer can lay the proper foundation that this is true and accurate video, this would also fit the prior consistent statement hearsay rule as well. So there's even a hearsay exception for this statement. There's also excited utterance if you really want to continue going down the hearsay exception rule. This is made at or near after a startling event. It's very clear from all the evidence in this case that this, calling it a startling event is, well, a complete minimization, but that's what the hearsay rule says. So there is clear hearsay exceptions for excited utterance and a statement of recent perception as well. So there's multiple different avenues of hearsay. This could be admissible. Regardless, there's a non-hearsay purpose. There's a purpose in responding to the exhibits the defense is putting in for their non-hearsay purpose. So for all of those reasons combined, these exhibits should be admissible.
Just address a couple of things. So,
Go ahead.
first of all, you know, this, again, we should, you know, exhibit 180,
181.
well, no, I'm sorry, exhibit 181 and 182 are, I believe, if I'm doing the math correctly, less than 30 seconds apart from one another. Exhibit, 1 second, 181, it says,
Yeah.
it ends at 4319, right?
Yeah.
Okay, and this starts at 43.
Yeah.
Okay. So exhibit 181 and 182 is 24, 1 second. 24 seconds apart from one another. So this idea about, oh, one is from earlier when she first gone down the hill, and then the other one's from later, you know, it's making out like it's like 5-10 minutes apart. It's about 24 seconds apart. So that's number one. Number two, again, you know, never brought this thing up about prior consistent statement until I mention it, and all of a sudden, that's what he wants to do. Well, you don't lay foundation for a prior inconsistent statement.
Prior consistent statement.
I'm sorry, you don't lay foundation for a prior consistent statement with a police officer a day after the person testified. If he wanted to do that, he could have tried with her. So, that's that. And so that's not how this works. And that's, you know, again, that's not what he was earlier saying he was even using this for. So, Your Honor, these things should stay out. I mean, like you said in the beginning, what's at the beginning of this trial, when we talked about body cam, you basically said anything audio on the body cam, you know, it's hearsay, it's not coming in. And so, you know, unless there's a viable non-hearsay purpose for it.
Well, unless there's an exception. It's hearsay, but if there's an exception. Right? Hearsay normally doesn't come in unless there's an exception.
I understand that. But, you know, again, now that's what he's saying it's for?
It's up to the order and judge.
Well, whether or not he says it before or says it after, is there a hearsay exception for the material to come in?
Well, if we take these things one at a time.
And I'm not concerned about excited utterance or
Okay.
Statement of recent perception. I'm focused on
So one
consistent statement.
Okay, so 179, you lying bitch, you whore, I can't do this anymore. She never said that on the stand. So it's not consistent with anything. That's a brand new statement. She never said that on the stand. She said on the stand, he said, I'm sick of this shit, get over here. So I don't know what that's consistent with. Now that this is the new theory we're trying to use.
Fair argument. As to
181,
please.
he was saying, don't leave our kids without parents. And he hit me with the rock 10 times. That's actually, excuse me?
She says, he hit me with the rock 10 times. I don't know.
Well, that's different from what she said on the stand. She said up as many as 10 times, so that's different. So that would be a prior inconsistent statement.
Well, she did testify up to 10 times. She wasn't sure, right, during her extensive examination, both direct and cross.
She said as many as 10 times. I don't know the exact amount.
Right, and that's what she says in the statement.
It's not what she said. Your Honor. She said 10 times. She didn't say up to or as many as 10 times.
No, she said, he hit me 10 times, I don't know. But
Right.
She doesn't know the number.
And I'm suggesting that's different than saying he hit me as many as 10 times, and then later on, in a different, under different questioning, saying, I'm not sure of the exact amount. That's different. that's different. Maybe not, in your mind, it's not a huge difference, but it's different. So it's not entirely consistent.
Okay, anything else you want to add?
No.
Counsel, I appreciate your thoughts. We might have to refine this further as well. With respect to what has been marked for identification as Defendant's Exhibit 182, again, subject to the laying of proper foundation through Corporal Chun, the clip can come in with the audio. It is for a non-hearsay purpose, and it will remain as Defendant's Exhibit 182. With respect to State's Exhibit 242,
I'm sorry, which is Defense Exhibit 179.
yes. The objection is granted in part, denied in part. It is for a non-hearsay purpose, as we discussed in Defendant's Exhibit 182. The first portion of the clip, before she's describing the incident, when she's giving her name, her condition is different than what's displayed in Defendant's 182. And it indicates the condition that Dr. Broschstein was talking about when she first entered into the ER, when her respiration was 23 as opposed to 18 when she was examined by the medical professionals. Non-hearsay purpose, the first, I think, 10 or 11 seconds of the clip can come in. Again, it's not hearsay. The remainder of the clip, the objection is sustained, not a prior consistent statement, and will sustain the objection. So that exhibit needs to get recrafted and shortened, and it can be State's Exhibit 242. What has been marked for State's Exhibit 243 and is Defendant's 181, it's this court's position that there are portions of it that are admissible as prior inconsistent statements under Hawaii Rule of Evidence 802.1 sub 2, and that is offered pursuant to 613C. And what I'm talking about, it's the number of times that she's hit by the rock, and she says, I don't know. I'll have to go back again to see how we can splice the clip so that it only allows in what's an exception to the hearsay rule under what the court just cited as a prior consistent statement. There are other portions that are not consistent that we're going to have to excise out as well. Counsel?
I'm sorry, Your Honor.
Yeah.
I'm just looking up the rule on my phone. I apologize. I'm not texting anyone.
Go ahead.
But just for clarification, I'm a little confused. So for Defense 181, I'm sorry, maybe I misunderstood, but you're saying that the part about how many times with the rock is consistent or inconsistent?
Consistent. It's
Okay,
a prior
so you're
consistent
saying that
statement.
it should come in under, it can possibly come in as a prior consistent statement?
Yes.
Okay, but, and the rest of it, so you just, so.
I'm not sure, so I want to go back and listen. It's a short clip. But there are
Correct.
other things, and I understand the argument that you make, Mr. Otake, and I agree with them. There are some things that are consistent. There are some things that are not. There are some things that cannot be consistent if she never testified to it previously. And that's what's driving the court's ruling.
Okay. Okay, so this is kind of what I'm talking about the foundation, okay? My understanding under HRE rule, 613C is, if we're gonna get into prior consistent statement, that's admissible to rehabilitate a witness's credibility after there has been evidence of inconsistent statement.
I'm looking at C2, and the rule states that evidence of a statement previously made by a witness that is consistent with the witness's testimony at trial is admissible to support the witness's credibility only if it is offered after an express or implied charge that has been made that the witness's testimony at trial has been recently fabricated or influenced by bias or other improper motive. Right? And the implication is she made this up to bolster the claims in the motion to set in the divorce case.
No, but this is, we embrace that she's always said that it's been 10 hits. We're not saying that she's never said that.
That's not what she said, though.
We're not trying, she's always said it's been as many as 10 hits or up to 10 hits. She's always said that. We're not saying that that's something.
That's not what she's saying. Right? She says up to 10.
That's what I just said. We embrace that she said, always has said, it's been up to 10 hits.
Right? She's been challenged on the number of hits. It is the trial examination both on direct and cross.
Okay, but I'm just trying to. Okay, so your ruling is that portion can be played, or
Yes.
just the part about the hits?
And whatever is, that's what I'm clear about is a prior consistent statement. I'm not sure about the rest of she describes the incident as well, right?
Right.
Right, and I'm not sure it's consistent, so I have to go back and listen to it again. It's a short clip. But the number of hits, to me, I'm clear and conclude that it is a prior consistent statement that's admissible.
Under 613.
And 802.1. But I want to listen to the remainder of the clip.
Assuming they can lay the foundation through this officer, but.
Correct. And I also want to go back and listen to other parts, because your argument makes sense to me, Mr. Otake, that some things that are on it are not necessarily consistent because she never testified to it before.
Right, or,
Which is the basis for the court's ruling on.
Understood.
Right, on defendant's 179, which is 242 for the state. So I want to go back and listen to 181 again to further refine the rule.
Okay.
Okay.
As to the relabeling,
242 is state's exhibit because it's not a defendant's exhibit. You have to redact a portion of it.
the new, when they make this new clip.
It's view 242. 182 defendant stays 182.
And then 181.
I think it's going to be 143 because it's going to have to get spliced. Because I don't think I'm relying all of it in.
Okay. That's, okay.
So recess. Let me go take a look at it and we can figure out the timestamps.
Okay, thank you, Your Honor.
25-373. Dr. Konig is present in court with all four counsel of record. Jury is still absent from the courtroom. Go ahead, Mr. Otake.
Thank you, Your Honor, and I apologize. I didn't have the rule up in front of me earlier, but this is what I was talking about the foundation.
I know where you're going.
802.1 reference you to 613.2, right?
Yes.
And 613.2 says, an express or implied charge has been made that the witness's testimony at the trial is recently fabricated or is influenced by bias or other improper statements. And this is the part. And a consistent statement was made before the bias, motive, or fabrication or other improper motives is alleged to have arisen. If you listen, I'm sure you did, when you heard my opening statement, what we've said is, we talked about unfaithful, unwilling, untrue, and we said that after she started this incident on the mountain, realizing a divorce was coming, she said many untrue things to the police to get the upper hand in the divorce. So this statement that they want to introduce is not made before the bias, motive, or fabrication is alleged to have arisen. We're saying this statement, even to right then and there, that's what we've always said. That she said these untrue things because she knew at that point a divorce was coming. So we're not saying that this motive arose later. We're saying it arose at that time. That's what we've always said. So, it doesn't meet the exception. And further evidence of that is, as I stated, when we started this morning, that's not where he was going with this. It was only when I raised it that all of a sudden he's trying to say it applies. But it doesn't apply because the consistent statement, I guess what's on 181, would have to have been made before the bias, motive, or fabrication or other improper motive is alleged to have arisen. And we're saying that at the time she made that statement, it was untrue because she had a bias interest motive in protecting herself and getting the upper hand and was clearly going to be divorced.
Okay, go ahead. Mr.
Yes, Your Honor. Opening statement should not be considered by the court for this purpose. The court should be considering the evidence and what happened on cross-examination. And what happened on cross-examination yesterday was Arielle Konig was crossed about what happened before the incident. Nothing about divorce was discussed before the incident. The only cross-examination or implied reason to fabricate anything about the divorce, Mr. Otake said, when you got back to Maui after the incident, that's when you filed for divorce, that's when you filed for the TRO, that's when you took the money out of the account. So the implication that Mr. Otake is making is that she had this motive to lie after the incident. There was no evidence brought up of any motive of Arielle Konig to fabricate this before she made this statement to the police. So temporally, this fits exactly into prior consistent statement.
I agree. However, Mr. Garner, when we look at Rule 613, the prior consistent statement needs to come into the witness herself. And that's the first line in Rule 613. So, court adjusts or reconsiders its ruling with respect to States Exhibit 243, which is defendant's 181. Objection is sustained. 242 can get amended, so that includes up to the first 11 seconds. That does show a difference in condition of Ms. Konig as opposed to what's depicted in 182. So 182 can come in subject to link or foundation. Likewise, the redacted states 242. Anything else we should take up?
No, thank you, Your Honor.
In terms of publishing, states 242. I will publish the first several seconds today. Pause the video, and similarly to States Exhibit 4, a separate exhibit will be made and
It's up to the 11-second mark.
understood.
That's a little dicey in case we don't pause it at the right time and the rest, you know what I mean? Like, it's right after, so I mean, I understand we don't want to take a break, but I'm just, I just,
You
if
wanna
we're
see
going to
the-
do that, we got to make sure that it's.
You want to say the 10-second mark just to be safe?
No, I agree that with what you're saying. I'm just saying if we're saying, like, if he tries to stop it and then it keeps playing because it doesn't stop, then the jury hears it. So I mean, if you're confident you can stop it right then before what's not allowed comes in, then it just seems risky. But I mean, you guys, if you think we can stop it, or maybe Mr. Dirks can be ready with the power button or something, I don't know. But
Do you want to give me a moment to practice?
Why don't you? Just, I think we should be safe. I mean, I understand the concern.
Okay, it is going to be on the screen up there because I'm currently confined. So States Exhibit 242, publishing from the beginning.
Her name?
Arielle Konig, A-R-I-E-L-L-E. Birthday is March 24th, 1989.
all right.
All right, we can do it.
Okay. Counsel, anything else we need to fight about before the jury comes back?
No, thank you, Your Honor. We weren't fighting, we're just talking.
Don't get me wrong, I call it a fight, but I appreciate the advocacy.
Yeah,
It
and
helps.
I apologize, I know sometimes I get animated, Your Honor, I mean no disrespect, thank you.
None is taken, and I appreciate the advocacy.
Thank you.
These trials bring up the best in everybody, so I appreciate it.
Thank you.